We're just waiting a moment for all the participants to finish joining.
Okay.
And I think we're good to go. Welcome to a public lecture by the American human rights lawyer Stephen Donziger entitled The Epic Environmental Litigation of Chevron and Ecuador, Lessons from the Frontlines. Good morning, my name is Stephen Wood. I'm a professor of law at the University of British Columbia and the director of the Center for Law and the Environment at the law school. This talk is being presented as part of the center's No-Fly Zone virtual speaker series, in which we hear from courageous and innovative lawyers, activists, and thinkers who are working on the front lines of environmental justice. Other speakers in the series include Mari Margil, a pioneer of rights of nature, animal justice lawyers Camille Labchuk and Victoria Schroff, and Anishinaabe lawyer Lindsay Burrows Kigata. I'd like to begin by acknowledging my presence as an uninvited guest on the ancestral and unceded territory of the Coast Salish, Musqueam, Squamish, and Tsleil-Waututh peoples, nations whose resilience and tenacity have enabled them not just to survive, but to develop and revitalize their laws and institutions as sovereign nations, even as their land has been occupied, transformed, polluted, stripped of natural resources, and crisscrossed with pipelines. An experience that bears similarities to the story we are going to hear from our guest. Stephen Donziger is a renowned advocate, writer, and public speaker at Donziger Law, www.donzigerlaw.com, with a focus on addressing human rights and corporate accountability. He's part of the team working with indigenous and farmer communities in the Lago Agrio region of the Ecuadorian Amazon rainforest, who are suffering from high cancer rates and other health ailments related to the massive intentional oil pollution caused by Texaco, now owned by Chevron. In 2011, the affected communities won a historic $9.5 billion US judgment against Chevron for the environmental cleanup of what experts consider to be one of the worst oil-related catastrophes in the world. So this is a story of victory by indigenous and poor communities against a giant global corporation, but it's also a story of corporate resistance to accountability and retaliation against environmental justice champions. Chevron has been a fugitive from justice for almost a decade now, removing all its assets from Ecuador just before the judgment was rendered and doing everything possible to avoid and delay its accounting. In 2010, Chevron spokesperson Don Campbell told a reporter, quote, "We're going to fight this until hell freezes over, and then we'll fight it out on the ice," end quote. But of course, instead, they're fighting it out as the world burns from the effects of the very fossil fuels that they spent decades pumping out of the ground. The other thing they did was retaliate in a most spectacular way against Ecuador, the plaintiffs, and their lawyers, including Stephen Donziger. And one thing my experience of bullies tells me is that the best way to understand what a bully is really doing is to look at what they accuse their opponents of doing. Chevron, aided by the US federal courts, has accused Stephen, the plaintiffs, and the other lawyers in the case of conspiracy, fraud, bribery, corruption, racketeering, intimidation, and victimizing the innocent. You'll hear more about his decade-long ordeal of persecution, including his current situation, pardon me, living under house arrest for almost 14 months, awaiting trial on charges of criminal contempt of court. Known for his, quote, Herculean tenacity, end quote, according to Businessweek, Stephen has represented the affected communities since first visiting the region in 1993. They are still waiting to turn their victory in court into justice on the ground. And just before I hand over to Stephen, a couple of logistics. The event is being recorded and it will be available on the Center for Law and the Environment website, which is Allard, www.ubc.ca/CLE. Stephen will speak for 20 to 30 minutes, after which there will be audience Q&A. Please pose your questions using the Q&A button at the bottom of your screens or wherever you find your Zoom meeting controls. Please don't use the chat or raise hand function just to keep things manageable and simple. We want to just use the Q&A function for that. I'll be moderating the questions along with the coordinator of the Center for Law and Environment, Veronica Plihal, who's with us today. So when you enter a question in the Q&A, could you, in addition to your question, indicate if you'd like to pose your question live to Stephen? We encourage live questions because it makes it more interactive. So what we'll do is, if we call on you to pose a question and you've indicated that you'd like to pose it live, we are hoping at least the technology will allow us to unmute your mic. And at that point, would you please state your name and pose your question concisely, and then Stephen will answer. We're going to close after 1 hour at the most, which is 10:30 a.m. Pacific time. And I'm now going to welcome Stephen to take over the virtual podium. So please go ahead, Stephen.
Thank you so much, Stefan, for that really nice introduction, and it was a very accurate and comprehensive one. So you'll have the good fortune to save me a little bit of time. I want to thank everyone at the Allard School of Law for inviting me. It's an honor. I'm familiar with British Columbia. I'm familiar with that part of the country. I've had the good fortune to be in Vancouver on a number of occasions. And I know the history of the province in terms of First Nations to some degree, and it's just an honor to be able to speak to people in Canada, which is a country that obviously has its challenges and problems, but compared to the United States at this point, looks like utter paradise. In any event, I'm going to briefly review this litigation. I know a lot of y'all are familiar with it, or at least the basics of it, and then I'm going to talk a little bit about some of the broader meaning of, you know, how I see it and what it means really for human rights law, indigenous rights law, corporate accountability, and really the future of young lawyers who want to do this type of work. So in a nutshell, I kind of fell into the case. I graduated from law school in the United States in 1991, and a classmate of mine, his father was from Ecuador, and he told us about this, and we all traveled down there to investigate what we had been told was one of the world's worst oil-related contaminations. And we went down on the first trip in April of 1993 with doctors and scientists and lawyers to investigate. And when we got there to this part of Ecuador's Amazon, which is the northern part of Ecuador's Amazon, just south of the Colombia border, we saw what to me as a layperson looked like a truly apocalyptic scene. There were literally in some parts of this area lakes of oil on the ground. There were hundreds and hundreds of these open air waste pits that Texaco, which had drilled in this area, had gouged out of the jungle, mostly in the 1970s and 1980s. And there were toxic contaminants, drilling muds in these pits, and many of them had pipes that had been constructed to the sides of the pits to kind of let the effluent, the toxic effluent, flow out into streams and rivers that it became very evident local communities were using for their drinking water, and for bathing and fishing and for their sustenance. And there were a myriad of other problems, including the fact that Texaco for years and years had this really awful practice of backing up these big tanker trucks and sucking with hoses some of these waste, some of the toxic cancer-causing waste out of the pits, putting it into the tankers, and then going along the dirt roads and just spewing it out the back and using the toxic cancer-causing oil as a mechanism to keep the dust down on these unpaved roads. And there was intense poverty, but I say that kind of with the caveat that before Texaco came to this part of Ecuador, there was really great prosperity among the indigenous groups who were living very healthy lives in the forest. They had all their needs met. Their cultures were thriving. They did not need money as we understand money, because the rainforest was their shelter, it was their hospital, it was their medicine, it was their food supply. And over time, as all this oil development happened in this area, there's 5 indigenous groups in the area. Really, maybe over 20 or 30 years, there was such a mass deliberate poisoning by Texaco that the indigenous groups that had prospered for millennia really became decimated. When some of the leaders of these communities confronted the Texaco engineers about why they were doing this, they were told lies. Things like, oh, the oil is good for you. It's like milk, it has vitamins in it. A lot of the communities were displaced from their territories because Texaco had the rights via its agreement with Ecuador's government to a 1,500 square mile area, which is an enormous area. And they built 6 main oil fields, hundreds of wells, and in every one they used the same substandard operational practices, meaning they built these unlined waste pits, they ran the waste into rivers and streams. As a cost-saving measure, they also took what's called water of production, which has benzene and other cancer-causing materials, and you have to separate the water from the oil when you drill. Normally, you're supposed to re-inject the water of production. It's poisonous, it's scalding hot as well, deep down into the ground in the same or different wellhead than the well you're bringing the oil up out of. It's the only way to safely dispose of this, but what Texaco did is they simply separated it out, ran it through these gigantic industrial-sized pipes into the rivers and streams, and that was like a separate source of cancer-causing oil waste running into the water supply, distinct from the ones from the pits that I just described. And in addition to this, there was massive gas flaring, pouring dioxins into the air. So the local population over time was getting hit from all sides. It was in the food supply, it was in the water supply, it was in the air. And really, the whole area became poisoned. And the sad part is, when we went down there in April 1993 and saw this awful situation, which was so evident when you just kind of look around with the naked eye, it's still going on today because this has never been cleaned up. And the way oil contamination works and the way these pits work is they still continue to pollute, and they still continue to pollute the water supply with predictable results, including significant death from cancer and other oil-related diseases. As a young lawyer at the time, I was out of law school less than 2 years at that point. I wanted to see if I could work with the team with whom we traveled there to do something about it. So the lead lawyer, a man named Cristobal Bonifaz, and myself and another law firm in Philadelphia, plaintiff side law firm called Cohn, Swift and Graff, we joined forces and we signed up clients and filed a class action lawsuit against Texaco in New York in November of 1993, which is almost 27 years ago. Of course, at that time, I had no idea on earth that any case could go on this long, or that I would end up playing the role in this case or any other case that I've ended up playing. But the abbreviated history is, over the first 10 years, we sued in New York because that's where Texaco's headquarters was, and that's where the decisions were made to pollute in Ecuador. Furthermore, the affected communities in Ecuador did not have enough faith in their own country's court system. My apologies for the noise. I'm in Manhattan. It's very noisy here. They did not have enough faith in their own country's court system to sue there. I mean, this had been pollution in an open and notorious way for many, many years. And there was not a single judgment, court judgment in tort for even $1 against Texaco in the entire time they operated in Ecuador. The government never even fined them. I think there was one fine of about $50 for this pollution. So they wanted the lawsuit in the United States. We wanted a jury in the United States to judge this case. Texaco fought ferociously and almost desperately to move the case back down to Ecuador, where they thought they could engineer a political dismissal. They filed 14 separate affidavits in the US court praising the fairness of Ecuador's judicial system. And ultimately, after a couple of rounds in the appellate court, they won that battle. But they lost a critical issue in the process, which is they had, as a condition of getting it into Ecuador, because of our pressure, they had to accept the jurisdiction of Ecuador's courts. And that was a critical issue. A lot of corporations in the United States, I imagine this might also be the case in Canada, when they get sued by foreign plaintiffs who accuse them of abuse or human rights violations, the first inclination, at least in this country, is to move it back to the host country, where often the legal systems are less, they're not as well equipped to deal with complex issues of proof and the like. So this happened, for example, in the Bhopal case in India against Union Carbide, which is a whole other kind of sordid history of a lack of a corporate accountability for a mass industrial chemical disaster in India. But in this case, Chevron, out of that same type of defense playbook, moved it into Ecuador. And at that point, I think they thought we would go away. Instead, we, meaning the Cone Swift law firm and others, organized a team of Ecuadorian lawyers, a fabulous team down there. And we then worked as really an international team at that point, led by the Ecuadorians who would appear in court. We refiled the same case in Ecuador under Ecuadorian law. And we quickly got to trial in October of 2003. And that was an enormous accomplishment, just getting to trial, because Texaco and then Chevron, by the way, bought Texaco in 2001. So right as the initial US phase of the litigation was ending, Texaco became Chevron. They actually called the company at the beginning ChevronToxico, and Chevron essentially took over the defense of the case. I think they thought we would go away. We obviously didn't. And even though they had accepted jurisdiction in Ecuador as a condition of the US court sending it down there, the first day in trial in October of 2003, one of the first things Chevron's lawyers did was to contest jurisdiction. And, that was kind of a wake-up call for me as a relatively young lawyer to understand that the degree of bad faith that Chevron used to defend itself from the litigation was shocking to me, even from that first day. Subsequent to that, they did everything they could to delay and obstruct the trial. We had Ecuador is a civil law system, unlike the common law system in Canada or the United States. So we had these field inspections of the contaminated Chevron well sites that went on for 4 or 5 years, that Chevron used largely to delay the trial or try to generate what we would call junk science to present to the court. For example, in a given well site, remember there were hundreds of these and dozens were being inspected as part of the trial. They would send teams out prior to the inspection to scout the site secretly to look for areas near the pits that seemed to be relatively clean. So when they would show up in front of the judge, they would sort of make it look like a random sample, but they had actually plotted it with data points before. They would pick soils from particular areas that were either far away from the waste pits or uphill from the waste pits, where they knew there would be fewer or no contaminants when these samples were sent to the labs. And it's very odd, isn't it, when you're trying to do an environmental assessment of an area that appears to be contaminated, to take your soil samples, not from the area that's contaminated, but from an area far away from the area that's contaminated. But this was all just, again, out of the corporate playbook, intended to not illuminate the truth, but to confuse the court. And this went on year after year after year. We still amassed a significant amount of evidence. There were ultimately 105 technical evidentiary reports submitted to the court with 64,000 chemical sampling results from both sides. And even though Chevron was, engaged in what I would call this effort to create junk science, they still, most of their samples still actually showed levels of toxic contamination in violation of Ecuadorian norms, which by the way were much more lax than those in the United States, and I would assume Canada. But there was still so much contamination that Ecuadorians' norms were clearly being violated. As Chevron realized that we had the capacity to generate the evidence and prove the case, they started to engage in even more what I would call corrupt acts. They filed, literally dozens of duplicative motions before the court in an attempt to really block the court from proceeding normally, to delay the trial. At one point, they sent one of their operatives, a guy named Diego Borja, in to meet with the judge on false pretenses to claim that he was a cleanup expert. He secretly taped the judge and then claimed that the judge had already decided which way he was going to rule, which turned out to be totally false. It was very clear Chevron was getting increasingly desperate, and while we were, as lawyers should, playing by the law and by the rules of the court, it was very clear that Chevron just saw the court as like another kind of tool that it would try to manipulate in service of a much larger power and profit agenda. They did not respect the court. They did not respect the judges. They filed motions threatening to put the judges in jail if they didn't rule in their favor. And ultimately, they decided that their main defense strategy, or one of their main defense strategies, would not be to litigate the case on the merits, but to demonize me. Literally, there's an email in 2009 that says, our long-term strategy is to demonize Donziger. And again, this is another component you might often see in corporate defense playbooks. Usually they don't work because most courts don't like that kind of thing, or at least they don't have a lot of patience for it. In this case, as it became clear that the court was about to issue its judgment, this is in 2011, 8 years after the trial started, 2 weeks before the judgment came out, Chevron sued me in New York under the RICO law, which is a US statute passed about 40 years ago by our Congress, 40 or 50 years ago, designed to target the mob, the mafia. And it's a statute that is mostly used in a criminal context, but what Chevron did, it also has a civil component that allows a private party to use it, and they used it on the theory that all of us that had been working on the case, and by that point we had been working on it 18 years, were not really human rights lawyers or environmental justice lawyers. We were part of a racketeering conspiracy whose objective was to extort money from Chevron. In other words, they tried to turn the tables and basically say that Chevron, which had its predecessor company, Texaco, had spent decades setting up this system that was designed to pollute, but they were actually the victims of the indigenous groups and other Amazon communities rather than the victimizer. Now, this seemed utterly preposterous to me, except for the fact that they hired one of our country's preeminent corporate law firms to do this, Gibson Dunn and Crutcher. Gibson Dunn literally used hundreds of lawyers. It was very clear that they gave Chevron a blank check. And this is what we are seeing now increasingly in the United States. It's really a SLAPP lawsuit, which is a harassment lawsuit designed to discourage advocacy and discourage corporate accountability and to silence the critics. And using the RICO statute to do this, and I'm hardly the first person targeted. A lot of people in this country, and I think this happens in your country too, get targeted by these things. But the level of comprehensiveness, of the amount of money being spent, the number of lawyers on it, really signaled to me that there was something seriously deep going on beyond just a normal litigation. And as I kind of step back, and I'll get to the detail of what's happened to me personally as a result of that case. As I kind of step back, I really think that Chevron concluded that this type of lawsuit, this type of human rights lawsuit, needed to be killed. I mean, it's not just the lawsuit itself, but the very idea of doing these kinds of lawsuits generally needed to be stopped. And we can go on for a lot of time about how the oil industry, the fossil fuel industry, is in structural decline, and it is because of global warming and other reasons. But it was very clear that Chevron and its allies in the oil industry and in the fossil fuel industry generally did not want this type of lawsuit to succeed. I think they were shocked. We won the case and had as much success as we did, and they decided to spend whatever it took to stop us. To do this, though, they, in my view, committed a massive fraud. Basically, since they had no evidence to stop the case, what they did is they enlisted a Ecuadorian man, and they paid him a huge sum of money, $2 million or more. He's a former judge in Ecuador. And they brought him and his family to the United States. They coached him, the lawyers at Gibson Dunn coached him for 53 days. And when he walked into the courtroom in the RICO case, the judge was a man named Lewis Kaplan, who himself was a former tobacco industry defense lawyer. This man got on the stand and lied and claimed that he had been in a meeting with me in Ecuador where I had approved our local counsel's bribe of the trial judge in exchange for our ability to actually write the trial judge's judgment against Chevron. Well, none of this happened. And the only evidence presented that it did happen was the words out of this man's mouth after he had been coached for 53 days by the Gibson Dunn lawyers. And there's one other critical fact that I want to make you all aware of, which is there was no jury in this case. Judge Kaplan, who had signaled to Chevron that he had very little respect for Ecuador's judiciary, handled the case alone. It is the first civil racketeering case in US history under this statute where an individual defendant was not given a jury. And I think both Judge Kaplan and Chevron knew that had a jury heard the case, there was a high degree of probability that Chevron would never have been able to secure the outcome of the case that it wanted. And Chevron was able to deny me a jury by engaging in really a trick. When you sue under civil RICO, you sue for treble damages, 3 times the amount of the damage. And at the time they sued, our judgment had yet to be heard on appeal. It's since been affirmed on appeal by Ecuador's 2 highest courts. But at the time, the judgment was around $19 or $20 billion with various court costs. Now that might seem a lot. It's actually a modest sum of money, according to scientists, compared with the magnitude of the damage. And by comparison, BP has paid 50-60 billion US for the Deepwater Horizon spill in the Gulf of Mexico in 2010. But in any event, it was about 20 billion. And under RICO, they sued me for treble that. They called it damages. They hadn't paid a penny, so I don't know what the damages are, but they were like these theoretical damages. And I then got sued for the largest amount of money of anyone in US history. So, potential liability was the largest in US history at $60 billion. I live in a fairly modest apartment in Manhattan with my wife and son. I work out of my apartment. I'm a sole practitioner. And, I got sued for the most money in American history for doing what I thought was good works and helping my clients win this judgment. So when under the US Constitution, if you're not sued for money, you are not entitled to a jury in a civil case. So the reason Chevron proceeded to drop the entire $60 billion in damages on the eve of the trial, like it was 2 weeks before the trial, is because they didn't want a jury, because they did not have enough confidence in their evidence and in this witness to whom they had paid $2 million for it to really pass muster in front of any objective fact finder. To make a long story short, predictably, this judge found me liable under civil RICO. It's a quasi-criminal statute, meaning he had to determine that I had committed multiple predicate felony acts to find me civilly liable. So think about that for a second. Under our law, if you're going to be convicted of a crime, the elements of the crime must be proven beyond a reasonable doubt. He convicted me without a jury of various crimes under a more probable than not civil standard. But when it came out in the press that I had been found liable, it looked like I had been found guilty of crimes, even though I never had due process as you would have in a normal criminal case. And I really didn't have due process as you would have even in a civil case. And then Chevron tried to use the judgment to block the ability of the Ecuadorians to enforce their judgment in other jurisdictions. Kaplan had barred them under this RICO case from enforcing in the United States, which I think is a grossly unfair decision and a pretty craven example of a US court trying to bail out a US company from a foreign liability. By this time, though, we had started to work with counsel in Canada, in Toronto, the Lenzner Slate law firm and some other people. And in 2012, prior to the RICO trial, we had filed an enforcement action in Canadian courts against Chevron and its wholly owned subsidiary in Canada called Chevron Canada. So running parallel with the RICO case was the Canadian enforcement action. And Chevron was trying to use the publicity generated by the RICO case to try to taint the Ecuadorian enforcement action, which was really based on a Canadian enforcement regime's interpretation of a foreign judgment, which, by the way, in a commercial context happens frequently all over the world. Like you get a judgment in one country, you go to another country to enforce it when there's no assets in that country. In a human rights context, though, Chevron, it took on this broader meaning. And over time, we were able to make some progress in Canada. In 2015, we won an enormously significant, I think somewhat overlooked Supreme Court decision from your country's Supreme Court that authorized the Ecuadorians to seek enforcement of the judgment in Canada. Chevron had tried to argue that they couldn't establish jurisdiction in Canada for various reasons. And this is a very significant decision for human rights and for indigenous rights and for corporate accountability. It also found that the defendant company didn't necessarily need to have assets in the jurisdiction where you're enforcing for the enforcement action to go forward, which is very significant because companies like Chevron move their assets around all the time from country to country to avoid liability. And subsequent to that victory in Canada's Supreme Court, and I'll wrap up with really these 2 points. One is in Canada, Chevron then tried to claim that we didn't, when we got back to the trial court, that we couldn't proceed because Chevron Canada was not a proper defendant because Chevron Canada had never been sued in Ecuador, if you can believe that. So shockingly to us, I mean, the normal kind of law as we understood it from our Canadian counsel was if you have a judgment against a parent company and they won't pay, you're allowed to take any asset, direct or indirect, under Canadian law to satisfy the judgment. And they tried to argue that, no, there's a corporate bail issue, even though there really wasn't. And corporate bail is when you have a judgment against a subsidiary that's undercapitalized and you try to go after the parent. But in this case, we had a judgment against the parent, but they were trying to argue that corporate bail protected the subsidiary from a debt collection. Unfortunately, after we had won 2 pretty good victories in the Ontario Court of Appeal, we lost that issue. And the Canadian Supreme Court denied review. So right now, the case, the enforcement case, as far as Canada is concerned, is in a state of repose. But the good thing about enforcement is there's no statute of limitations. Chevron has assets in many, many countries around the world, many rule of law countries, Australia, and many European countries, among them the UK. So there remain many, many options for the Ecuadorians to enforce their judgment. Chevron, in the meantime, continued to come after me. And I think when they saw the role I was playing and the efforts to enforce the judgment in Canada, the success, they went back to Judge Kaplan and tried to claim that the fact that I was helping my clients sell some of their interest in the judgment for third-party litigation financing to support all these efforts. And by the way, even though Chevron was spending probably $2-3 billion, we had to spend 0.5% of that is still a few $1,000,000. Like, you need resources to do these cases. And they claimed I wasn't allowed to do that under Judge Kaplan's original RICO decision, even though he'd expressly said we could raise money in that fashion. So as a result of this effort to kind of reinitiate the RICO case, which is to me another slap attack designed to really block my ability to work, Judge Kaplan asked, or ordered me, I should say, to turn over my computer and cell phone to Chevron. He stripped me of all my privileges, meaning my attorney-client privileges and other privacy protections that exist in US law, on the theory that I hadn't cooperated with his completely unreasonable discovery requests. And when I appealed this to the New York Federal Appeals Court back in May or June of 2019, a few weeks later, he charged me with criminal contempt. Now, I don't know how much power judges in Canada have to charge lawyers with criminal contempt to appear before them. But in the United States, when a federal judge does that, he or she first has to take it to the US attorney to see if they'll do the case. And in this case, the US attorney rejected the case. Judge Kaplan then proceeded to appoint a private law firm. Law firm is named Seward and Kissel to prosecute me. It turns out, we found this out 7 months later, that Seward and Kissel has Chevron as a client and has extensive financial ties to all the oil majors and entities in the oil industry. And he also, Judge Kaplan also assigned the case to a judge rather than going through the random case selection process. And the judge to whom he assigned it is a member of the Federalist Society. You might know that organization. It's a very powerful, pro-corporate, right-wing judicial organization in the US that essentially hands Donald Trump the names of its approved candidates for appointment to the federal judiciary, which is a role that the American Bar Association used to play. It's now the Federalist Society. And the Federalist Society is funded by big corporations. And Chevron is a major donor to the Federalist Society, which is yet another major conflict of interest. This judge, on my first day I appeared, which was August 6th of last year, proceeded to lock me up. She put an ankle bracelet on me, ordered me to go to my apartment. I can only leave since then, which is almost 14 months ago, with the permission of a court officer 48 hours in advance for just essential things like family, important family functions, legal meetings and the like, medical appointments. There's been times I've been days and days and days unable to leave my apartment. I can't even go into the hallway to pick up the newspaper from the door. I can't go in the lobby without permission. It's complicated, and I think it's wrongful, and I think it violates all sorts of laws, and I think it's unjust, but I've been unable to get the Second Circuit Court of Appeals to reverse Judge Preska's decision to detain me. She also slapped an $800,000 bond on me. This is a misdemeanor case, meaning in US law, the maximum sentence possible, if convicted, is 6 months in prison. Again, I've already been in my house almost 14 months. Because of COVID, there's no trials, criminal trials happening in New York right now. And it's very unclear when my trial is going to happen and what kind of trial I would even have, because they're denying me a jury again, even though I'm now facing prison. And I'm in a perilous situation. Now, how do I see this? And this will be my last comment. We can open it up. I don't want you to look at me and feel sorry for me. I really don't. I don't want you to look at my situation and be frightened to do this kind of work. I think this is totally aberrational, even for the United States, which, as you know, is a country drifting toward authoritarianism. Hopefully that will be reversed soon, but it is the state of play now in the United States. This is happening really for two main reasons. One is we won the case. The Ecuadorians won the case, as Stepan pointed out in the introduction. And number two is the risk from that victory in terms of the business model of the fossil fuel industry generally, and obviously Chevron in particular, is at great risk because of this case and the model that the case represents. That is, if people like you who want to do this work look at this as an inspiration, look at it as a model that could be replicated in Canada or other countries, that would really pose a serious and perhaps even existential threat to the fossil fuel industry alongside climate change and all the other problems that the industry currently faces. So the last thing Chevron wants to do is sort of give communities, vulnerable communities, any kind of hope that they can do this successfully. They want to hold my scalp up as like a trophy to their brethren in the industry, and as a mechanism, I think, to intimidate lawyers and activists who would get into this work and work to hold Chevron and other companies accountable. I am hopeful that I will personally get through this situation. We're battling on a lot of fronts. I'm blessed to have a lot of lawyers helping me pro bono in the United States and other countries. And I'm confident we will get through this. But regardless of my personal fate, the case is alive and well. We have lawyers in Canada and other countries looking at all sorts of enforcement opportunities. And really the reason this is happening to me personally is because we won, not because we lost. And I just want to be clear about that. Thank you for your time. I hope that was at least minimally coherent. It's a long history. And that was one of my longer explanations. I'm usually much faster than that, but I'm happy to open it up to questions. Thank you so much.
Thank you, Stephen. It's hard to have a really robust round of applause via Zoom, but imagine you're hearing a lot of applause right now. We're going to open up for questions now, and that means that attendees can enter questions using the Q&A function at wherever you have your Zoom meeting controls. You should see a button called Q&A, and you can begin to enter questions into that. Please, when you enter a question, also indicate if you would like to pose the question live. Stephen encourages that. We encourage that for a more interactive experience. If you do, when we get to your question, we will try to figure out how to enable you to speak. We're hoping that works. But if it doesn't, we apologize in advance, and we would read the questions out. Please go ahead and put questions into the Q&A. As people are formulating their questions, Stephen, maybe I will start and get your thoughts on something. So it's a situation that I think many people hearing this story, especially if they're hearing it for the first time, may have their faith in American legal institutions shaken somewhat. And I wonder what you think needs to happen or could happen to restore confidence or restore faith in the US justice system to appropriately deal with situations of environmental or human rights abuse like this.
Well, that's a complicated question. I mean, I think fundamentally judicial systems need to be, the politics needs to be taken out of the judicial appointments process. I mean, my experience in Canada, and I've been in your country probably 20 times since 2012 in courts and dealing with lawyers, and I know it's not perfect, but it seems to me the process of selecting judges and the process of litigating in Canada is much more civilized, much more rule of law oriented, even the way adversary lawyers treat each other. Like the idea that a law firm would sue a lawyer in Canada for litigating to me is just sacrilege. I don't think that would happen in your country, but in the United States, it happens all the time. And it happens because judges on the federal bench in particular, but also state courts, overwhelmingly, I think, come out of a pretty politicized selection process. Most of them come out of corporate law firms. It is really hard to find a federal judge. There's about 800 of them in the United States that comes out of a human rights background or even a criminal defense background. You know, it's almost like the corporate court. Now, I'm not saying those courts are incapable of producing rule of law decisions. I mean, they do generally do their jobs conscientiously. But when you have lifetime appointments from a very politicized selection process, which has gotten worse under the current administration, given what's going on now, and also you can see with our new Supreme Court nominee, it just becomes a greater and greater problem. And one of the byproducts is that it has produced a significant amount of hostility in our federal court system against human rights, you know, against environmental justice. You know, the progress of the world to combat global warming over the last few years is amazing. But like in the United States, the courts generally are very hostile to these climate litigation cases, to the Ecuador case, to what's happening to me, you know, these slap lawsuits designed to stifle dissent. So it really raises the cost to people like me and others who want to do this work when you want to do it on the scale that's commensurate with the problem, which is big. You know, you could do an individual case. It usually doesn't happen for an individual or a community, something that isn't as kind of systemically threatening to the industry. But when you do the larger cases that really take on the big issues, there is often a great deal of hostility. I mean, I think in this case, a lot of the lawyers in the Gibson Dunn firm, you know, some of them have gone on to the federal bench, many of them come out of the government, and there's this revolving door. And like when you're doing human rights work, you're kind of not part of that club. So when you show up with your case, it just becomes, it's a much more difficult uphill battle. Now, I don't mean to disparage US courts in any way, shape, or form. I'm talking about a phenomenon that's widely recognized in the academic literature. And I don't mean to disparage any particular judge, although I have honestly disparaged Judge Kaplan. I just don't believe he's followed the rule of law in the RICO case. But there are mechanisms to deal with that we've tried to avail ourselves with, both in the United States and internationally, that we will continue to use. So it's a real problem though, and I think, I mean, I said at the top, I really like your country. I mean, one of the reasons, if you look at the jurisprudence in Canada, like the Nevson case, the recent case out of Eritrea, I mean, that's just something you just don't see anymore in the United States. I mean, you know, our Supreme Court has gone in the opposite direction, limiting the ability of foreign human rights victims to come to US courts to hold US corporations accountable for their human rights violations abroad. You know, that they pretty much block those cases from even happening, whereas your Supreme Court is moving in the opposite direction. And if you want to set up an incentive structure for commerce in the world, don't you want a system where if a corporation goes, a mining company goes from Canada to Africa, or an oil company goes from the United States to Ecuador, don't you want a legal regime that gives those companies the incentive to treat people with respect and dignity and not enslave them or pollute their ancestral lands in a way that ends up killing thousands of people? Of course you do. So our court systems, in my view, are moving in completely opposite directions. Yours is moving in a good direction, ours is not. And I think it's worth noting that here we are, two advanced capitalist societies, neighbors, we live side by side. Things could not be more different. We aspire now to what you do. There might have been a time where Canadians aspired to do what we did. I mean, I don't know. But I find a lot of Americans are looking to other countries now with admiration, and they're bemoaning what's happening in our country. And of course, it all boils down to politics. You're seeing it play out now in our country with the election in a very vivid way. But it's a real serious problem. in our country with our, in my opinion, with a judiciary that's very hostile to human rights victims.
Thanks, Stephen. I'm going to go to a question from Megan Robinson, who's going to propose a question herself. And after that, there's a question from Eden Luimes. I'm not sure if Eden is going to pose it directly or not, but we'll determine that right after Megan. So let's hope this works.
Hi, Stephen. Can you hear me?
Yes, I can. Hi, Megan.
Perfect. First of all, thank you so much you really do inspire the people who are hoping to follow in your footsteps. So thank you. If you could go back to the first year of the case, knowing what you know now, what do you think you would do differently?
That's a really, really good question. I occasionally get asked that question, like, would you really do this if you knew it was going to last 27 years? So look, the answer is I'm really super proud of the work our team has done. I'm proud of myself. You know, I don't enjoy what I'm dealing with now, but, you know, sometimes these prices have to be paid to kind of move it forward, if you know what I'm saying. Had I known in the first year that this would happen to me, would I have done the same things? I mean, probably. You know, I mean, I never expected this kind of thing to happen. I still can't believe it's happening, and I don't think it should be happening. And I have enough faith in our system to feel optimistic that it will stop happening and it will be reversed, and those doing it will be held appropriately accountable. You know, one thing about life, and I'll say this as an older, you know, advocate who's been around for many years to younger lawyers, is, you know, you never really know where stuff goes when you make choices, you know. So in my case, you know, going down to Ecuador in 1993, I had no idea, you know, that this lawsuit would become what it is today. And nor did I understand that I would take the kind of role I've ended up playing for various reasons related to my availability and the fact I wanted to work in Latin America and all sorts of reasons why I kind of ended up being, you know, a driving force of the case. But you just sort of take your responsibilities to your clients seriously. I mean, you know, you take on vulnerable clients who have nobody. You know, you really become somewhat of a lifeline, you and your teammates, and you know, you have to keep going. I mean, the reason they're trying to knock me out, and you know, I'm not the only lawyer being attacked in this case. Others have been attacked, not with the ferocity they're attacking me, but the reason they're trying to knock us out, knock me out in particular, is because, again, because of our success, because of our commitment to our clients. That's a principle that you really need to, as you know, take extremely seriously. I mean, Chevron's entire defense strategy is to get rid of the lawyers so the people they poison and victimize in Ecuador are defenseless, because without lawyers, there's no case. They don't know how to get into court themselves. It's a real cheap trick to go after lawyers. So I just refuse to succumb to this. And it's caused, you know, tremendous hardship for me and my family. I have a wife and a 14-year-old son. But we're strong, and we still create happiness in our home every day. We have dinner, and we were able to get through this. And there's a huge amount of support, by the way. Even talking today gives me a great curative, therapeutic boost. You know, I mean, and I get invited to speak, and 29 Nobel laureates have issued a statement on my behalf. And you know, I had a bar hearing, by the way. They tried to disbar me. I had a hearing. I won that. I had 15 lawyers come in and vouch for my integrity. You know, in an odd way, this has created a situation where the case is getting more attention, and I'm getting a huge amount of personal support that is like it's solidarity and allows this thing to propel forward. But I really, I don't think I'd do anything differently. One other little caveat. Of course, in a long litigation, you look at decisions you made, you would change them with the benefit of hindsight. I mean, there's a lot of those, but they're not fundamental. The fundamental commitment to justice, to evidence, to truth, to accountability has always been the same and will not go away.
Thank you so much for that, Stephen. Uh, we're going to go to a question from Eden Luimes. If Eden is there, go ahead. But before you do, I would just give a heads up that after that, there's a question from Rick Reebstein, and we'll see if we can get you set up to pose that to Stephen. So go ahead, Eden.
Thank you. Thank you so much, Stephen, for everything you've shared and for the work you do. It's so important. And yeah, like Megan said, it's truly inspirational, what you've gone through personally and what you've done for these affected communities. I had a question relating to the indigenous communities you mentioned in Ecuador. I was wondering, what is the current state of the cleanup or the situation that those communities are in now? You mentioned that Chevron didn't have to do any cleanup following the case.
Thank you for your question. So in a nutshell, you know, when the communities won the case and the judgment was affirmed, a few years before that, Chevron had sold all of its assets in Ecuador. And they basically created a situation of like, chase me around the world. It's a mockery of the rule of law in my view. So there has been no cleanup. There hasn't been a penny spent on cleanup. You know, Texaco over the years would spend money on donations to plant trees and along highways in Quito, and they never did a damn thing for the communities affected. There's been no cleanup. I mean, you know, they've used 60 law firms, 2,000 lawyers plus. They're spending massively to not spend on what they should be spending, which is respecting the people of Ecuador and complying with the rule of law and paying the judgment. So they made a choice, you know, and it's unfortunately a typical choice for an industry that has shown time and time again that it doesn't want to step up and deal with the planetary crisis, and you know, will just do whatever it can to increase its profits as the planet hurts. And you know, courts need to play their role in holding this company accountable, you know, but when you can go into a US court and sue the lawyer and get the results they've gotten against me, you know, it gives them a false sense of confidence. Like, oh, we don't have to pay. You know, we have this judgment against Donziger. And if they end up in Australia or France or Indonesia or any of dozens of countries, say, well, look, this case is a fraud. This US judge, you know, looked at all the evidence, which he didn't. By the way, he excluded all the environmental evidence that had been used in Ecuador to find Chevron liable. He wouldn't hear any of that in the RICO case. And they just, you know, they just sort of think that the strategy works. I'm not so sure they're right, but I can understand how rationally those making decisions in Chevron might think that at this moment in time. So that's the dynamic that needs to change. And that dynamic can change through accountability, through courts, through media, through organizing, through lawyers like yourselves caring, through solidarity networks, through a law student coalition forming in solidarity with the Ecuadorians, you know, through pressure in Canada, perhaps via provincial governments, that Chevron really shouldn't be allowed to just show up and bid on projects in Canada until it shows it can comply with the rule of law in other places it's operated. That just happened in Israel, by the way, where Chevron tried to buy offshore gas assets, and environmental groups in Israel put up a huge stink about it because of the Ecuador and Nigeria situation. So, you know, look, you know, as people who care about saving the planet, who care about justice, care about human rights, we need to take our social capital, our solidarity with each other, and move it around the world as easily as Chevron moves its financial capital around the world to avoid accountability. You know, so when they go to Israel, we show up. You know, when they try to bid on a project in BC or Alberta, you show up and you start making noise. And to me, that's critical to create kind of a global network of power and leverage to prevent this industry from, you know, cutting and running, polluting the hell out of a place. And they do this, by the way, in lots of places. Ecuador is not the only place. From cutting and running leaving taxpayers and local communities with the bill for cleanup while they take out the profits, and then they show up in Canada as if they're just a company in good standing to bid equal to every other oil and gas company as if there's no problem. That has to stop.
So thank you for that, Stephen. We have time for one last question, but I must say, we're seeing the questions that are coming in. The entire audience isn't necessarily seeing them until we answer them, but there are some really, really thoughtful and deep questions coming in. Some of them could keep us here all day. Even this last question that's going to be posed is short and sweet, but I think it could lead to a very long discussion. So let's see how quickly we can deal with that.
Is that your Canadian nice way of saying, please keep my answers short?
Not at all. Where would you get that idea? But, I think Rick Reebstein has the mic now, so go ahead.
And just very briefly, thank you so much. What do you think of the chances of the complaint that has been lodged against Judge Kaplan for judicial misconduct?
So for those who don't know, 37 bar associations around the world just put in a complaint about Judge Kaplan. I don't know the answer to that. You know, our federal courts, there's very, very little accountability. I mean, you know, that's a mechanism that every federal circuit court has for citizens to file complaints. I don't know one that succeeded in recent years. You know, you're basically asking the police to police themselves. You're asking judges to police themselves. And what I found is that's not the most effective mechanism to create independent accountability. However, the complaint itself, the substance of it, and by the way, for those interested, I put all this stuff out on my Twitter feed, which is @SDonziger. If you want to follow me, and you can see you can click on the complaint on my Twitter feed if you go down a few tweets. You know, this is a really substantive, comprehensive complaint. And, you know, the proper thing would be for the chief judge in New York, Robert Katzman, to appoint a committee to investigate it. You know, but I don't know if that's going to happen or not. It's a very secretive process. There's very little transparency, but, you know, you just have to have faith in the mechanisms that exist. And keep pushing, because, you know, at a minimum, the judges on the appellate court that oversees the trial court where Judge Kaplan sits are going to read that, and they're going to learn about what's really happened in this case. And ultimately, I think it's an embarrassment for our federal judiciary and for our country that this is happening, that you lock up a lawyer in a society like the United States of America for advocating for human rights. Now they claim it's like discovery violations, computer settlement. I get all that, but like fundamentally, let's not kid ourselves about why this is happening. So I am hopeful that that complaint will get some traction. You know, we'll see. Our strategy is to avail ourselves as many of these mechanisms to put in information as possible to hold those who are doing this accountable, and that's one of them. By the way, I didn't do the complaint. It came from a bunch of other lawyers. I just want to be clear about that, but they did consult with me.
Well, thank you so much for everything you've shared with us, Stephen, and thank you to all of our attendees for attending. I know that we had attendees from multiple countries, so thank you so much for the interest. I think with that, we'll bring the event to a close with great appreciation. Even if you can't hear us applauding Stephen, thank you so much for everything that you have done, everything that you're doing, and will continue to do. And yeah, that is all for now. Thank you so much.
Can I just say one quick thing before we shut down? First of all, thank you to everybody for coming. Again, I appreciate the opportunity to share my perspective. If any of you want to follow this a little more closely, follow me on Twitter. We also have a website called MakeChevronCleanup.com where you can sign up for our mailing list, and people sign up to take action. It's MakeChevronCleanup.com. If you have a particular interest in getting involved, please contact me directly by contacting Stefan, and he'll tell you where you can find me. We actually use a lot of law students from U.S. law schools who help us with various projects, and it's usually a great experience for them and very beneficial to us. So I wanted to just mention that before as a good organizer, you always got to throw that out there before you sign off. But thank you very much. I really appreciate the opportunity to speak.
Okay, and thank you, and goodbye, everybody. Thank you so much.